Welcome to another edition of the Litigation and Psychology Podcast, brought to you by Courtroom Sciences. I am Dr. Bill Kanasky. My guest today is a good friend from Birmingham, Alabama. That's my Forrest Gump reference, Alabama. Jim Pattillo from Christian and Small. Jim, how are you today?
I'm doing great. Appreciate you having me on.
This is, I've been working with your firm for a long time, know many people at the firm. I love Birmingham. I didn't know if you knew this. My niece, who, by the way, is 6'3", plays on the volleyball team at Samford University, local
Oh,
there
cool.
in Birmingham. So my last trip, when I was up there, I got to see your colleague and very good friend Neil Moore, and I got to see my all 6'3" of my niece, who is a just killer beast of a volleyball player there in Birmingham, and she loves Birmingham. Let me ask you that: are you originally from Birmingham?
No, I'm not. And you haven't gotten to the Roll Tide comment. I would have stopped you short of that. I actually grew up in Florida, and I'm a Florida Gator by education and by allegiance too. So Birmingham is new to me just in the last 25 years.
Well, I'm not sure if you're aware of this. I attained my Ph.D. from the University of Florida, and those we had my first son in Gainesville, and Gainesville's a great spot, great school. I need to get back up there. Um, is life difficult being a Florida Gator in the middle of Auburn and Alabama land? Are you allowed to put a Gator flag outside your house, or like people are going to burn it down, or how does that work?
Well, it's of course the answer is it depends. And with Florida knocking off #1 Auburn in basketball
I
last
watched that
Saturday,
game.
it's a good week to be a Gator up here.
Yeah,
Uh,
yeah.
so
Uh,
so
Football
you
season,
know,
not so much. The Gators need to get together. Another kind of local question is, um, right now, and we're going to post this later, but at this point, Auburn and Alabama are ranked number 1 and 2 in the nation. Not in football, Jim. Not in football. In basketball. How is the state of Alabama dealing with this? Because I did not see this coming. Number one, you are in a football state, Jim. You're not. This is not a
yeah.
basketball state. How? Well, two things. How is the community handling this? Number one, and then number two, is this Alabama's coach? Is his head already on the platter 1 year in?
The football coach.
Yeah, the football coach.
Yeah, I think to answer question #1, and first of all, for context, Florida is #3, so let's just
There,
finish out that
yeah,
pecking order. Honestly, the basketball success for Auburn and Alabama is coming at a really good time, coming off pretty poor football season. So I
yeah.
think it's kind of a salve to the wound of people who are a little frustrated on the football end. But it's a good time and it's a good basketball to watch. I don't know if you saw, did you see Carl Ravage's comment about how competitive the SEC is because they are, I think,
It's 82 and
17 and
82.
70. Yeah, 82 and 80. Well, Carl, every time we play a game, you got one winner and one loser. So let's do the math there,
You
buddy.
know, everybody makes mistakes. And then he tried to weasel his way out of it on X. He should have just said, "Yeah, I was an idiot," but
You should have fell on the sword.
it happens. All right, so you're a defense attorney in Birmingham, Alabama. How was I liked asking most of my guests this same question, kind of like, what was it about law? Was law always the plan? I have many of guests that said, "Yeah, I knew I was going to be a trial attorney when I was 12," and I'm like, "Seriously?" They're like, "Yeah." And then others were like, "Well, I was going to be a doctor, and then I couldn't get into medical school, so I'm like, hey, I went in the law." What's your story?
Yeah, so my dad did the same thing for 40 plus years of his career that I am doing now. So I got to see one side of it from a pretty early age and was fairly convinced that I was not going to do it because of that. I saw the hours he worked and the time he put in. Now the practice has changed. The way we practice has changed the way and we'll talk about this in this podcast today, the
Yeah.
way lawyers treat each other has changed for the worse.
Yeah.
But so I was, like a lot of kids, wanted to be a major league baseball player, played all the sports growing up, baseball in college, and then kind of got those competitive juices developed.
Yeah.
And I landed in a job at a small insurance defense firm out of law school and got to try a lot of current cases, second
Yeah.
chair med mal cases early. And it really kind of touched that nerve, scratched that itch for me to compete. So I did not think I would end up litigating, but I have loved every minute of it. Once I've started doing it, and the other aspect of it that I really love is the chance to mentor and train younger lawyers here at Christian and Small now, especially, and that's been a real passion of mine.
I have some questions about that towards the end of this session that I want to get to because I try to hit
Awesome.
that with every guest. Every guest, I think it's important to add because I think it's such an important topic. And every firm kind of handles mentoring and training different. So I certainly want to get to that. What types of litigation are you handling these days?
So my practice profile today is sort of threefold. I'm doing some general commercial work, and that includes some slip and falls, catastrophic injuries of any kind, anything in the commercial sort of insurance context. Second, I'm doing a fair amount of product liability work, some software product liability specifically. And then third, I'm sort of back in the insurance context doing extra contractual and bad faith work. That also involves some coverage work, and even some SIU fraud investigation as well.
Pretty diverse. You and I have worked together before. You are a very talented attorney, and you've had a lot of interactions, obviously over the years, with your adversaries. And I want to put this in the context, okay? Because we just did a podcast a few weeks ago, which got a huge amount of feedback, positive feedback, which is always good. Which we went over the different types of witnesses that we see. So Steve Wood, my colleague, and I went through, the nervous witness, the angry witness, the disgruntled former employee, to kind of categorize the types of witnesses that we see and kind of how we tend to handle them. And then you could also do this for the attorneys, right? And specifically for you're a defense attorney, so you go up against various plaintiff attorneys, and they come in various forms. And this is across the country. This is not just in Birmingham. I think this is a pretty widespread topic. Everybody's different, and I think you're going to break down some of your experiences today. But before we get into the specific categories and kind of how you deal with those various situations, you said something very important, Jim. There's been and maybe it's just a breakdown in our general society about how we treat each other, but you kind of implied that the way attorneys treat each other today has worsened. And I'm 23 years into this. I've seen it worsen. What happened? What's going on? Is it more general society? Is it just the pressures of litigation, or is it just a new generation? I mean, you have to understand, half the people I've worked with are now retired, and they handle things very
Yeah.
differently. You have, boomers retiring, Gen X coming up into those premium positions. Then you got your millennial attorneys, and now the Z behind them. Is it a generational thing? What do you think is going on here? Because things certainly aren't positive and professional like maybe they were at some point in time.
Yeah, and there are certainly, I would say on average, most of my interactions are great with plaintiffs' lawyers, the other side of the bar. I think the reason for the sort of the slow bleed of civility is twofold. First of all, I think it is generational. I think younger lawyers are more prone less prone to pick up the phone, less prone to interact with people in person, more prone to email or even text. And we've all seen those keyboard warriors who are tough,
Yep.
tough with the keystroke. But you see them in person or pick up the phone, and they're sometimes literally a completely different person.
Yeah.
So I think that part of it's a generational thing, and the other part of it is just a societal. You can blame it on technology. You can blame it on any number of things, but we just don't take time to see each other as much. I do think there's sort of a hierarchy of communication that promotes civility. First of all, if you can sit down with someone in person, if I mean, they're more expensive to the clients, and I get it, but in-person court hearings are fantastic. As a matter of fact, Calhoun County has in Alabama has been known for what is the mass docket call, where they call every single case on their court docket, and you have 60 or 70 lawyers show up for a 30-second, is this case ready for trial or not? Seems extremely inefficient, but I see everyone I have a case with just about if I go to that, or if an associate now goes to that. And then, getting younger lawyers to pick up the phone first. First of all, with clients, it gets more things done in a shorter period of time. But you also tend to develop a rapport like you and I did. We talked about college football to start out
Yeah,
the call.
exactly.
If you can do stuff like that with a plaintiff's lawyer, I've got opposing counsel. I know their kids and what sports they play, and I'll know if I'll see them at the ballpark on the weekend. That all a lot of times that starts in a phone call. And then, you devolve into email, and we all have struggled. And I've got some examples of that we can talk about of just the bombastic nature of people who have an axe to grind. They can do it over email, but they won't do it to your face. So,
Yeah.
yeah, the technology piece of it has certainly not helped things.
So before we get into the categories that you've come up with, which I think are pretty funny, but it's just that they're accurate though, right? How do you so when you have an ongoing relationship with a plaintiff attorney, that's something that you can work on over time. But I'm assuming oftentimes or sometimes you're dealing with a plaintiff attorney you've never dealt with before, or maybe somebody that's an attorney from out of state or something like that. What are some of the tips that you have to kind of develop that initial relationship to kind of get things started on the right track, so perhaps it's not so adversarial?
Well, I think, first of all, I think every lawyer has to realize that whether they like it or not, and whether it's good or bad, they have a reputation. So when a plaintiff's lawyer files a case, one of the first things they want to know is, well, who did the defendant or the carrier hire to represent them? And are they experienced in the courtroom? Will they do a good job? Are they easy to work with? Are they vulnerable in certain areas? So um, I tell our younger lawyers, you really got to take time to curate your reputation for integrity and honesty, because it will precede you. People will have an impression of you before that, but when you get into litigation, if it's somebody I don't know, I mean, I think they know something about me. Um, um, it's always easy to pick up the phone with
Yeah.
your client's permission and say, "Hey, I haven't really gotten the claim file yet. I haven't talked to the client, but I just wanted to call and kind of just see where you think this thing is headed, and expect it to be some, big, horrible, awful thing you've got to deal with. But just get the conversation going, is real important." And I think typically my clients appreciate that. It is easy to not do that because we can get a case in. I can say, so and so, go get to work on the answer. Let's get discovery out. And I've got 18 other fires to put out, and let's get the paper going. And all of a sudden you're down the road, and you may have missed an opportunity to make some progress pretty early on in the case.
Yeah. So developing a cordial relationship, developing a good, good lines of communication is certainly going to benefit you in the future. So let's go through some of these categories. These are in no particular order. Okay. So plaintiff attorney category. This is going to be very interesting. So we have a category. Let's just call them. This is going from our outline that we have that we exchanged. The unqualified, incompetent attorney. Now, I have heard from clients and other attorneys that these types of attorneys, and whether it's true competence or lack of experience or wherever the lack of whatever is coming from, that from the defense attorney standpoint, it's very frustrating to the defense attorney because nothing goes smoothly. What are your thoughts on this category, and how do you deal with that?
Yeah, it's hard if I had a recent case where there was a Florida, I think it was a Florida or Georgia firm that was running some roofing cases in Alabama. I think it was a Georgia firm, and they were simply just applying the state law. They were familiar with quoting wrong statutes in the complaint for attorney's fees, a lot of that kind of stuff. It is hard to pick up the phone and tell someone, hey, you're kind of way off base here. So a lot of those kind of issues, you really just got to handle the issues with the judge and the court. I think a lot of those folks who are either unqualified or not quite as up to snuff on where they're practicing, you'll get their attention when they realize they've got to get in the car and send someone to court in North Alabama, or Southern Mississippi or wherever the case is pending. But you can do that pretty early on in the case. I think that's if you can find some legal issues that the judge can address with a minimum of time investment on both sides, just to help them understand, hey, we really are paying attention to this case, and you really have some legal issues, some issues with the law that you're kind of off base on. I think we don't want to file frivolous or extra motions, but if you got a basis for a motion to dismiss on an issue, go ahead and assert it early. Call them and say, hey, this is where this is headed. Happy to talk about it with you, but we need to get this addressed up front, and then start talking about the real issues in the case.
Yeah. All right, let's go to our second category. This will be the controversial one. Let's just call it for what it is. We'll call it the asshole category. Um, and and to be fair, I may have a plaintiff attorney on to categorize defense attorneys, but I think what you'll find is doesn't really matter which side you're on. You may get kind of all these categories on both sides in some way. But
Absolutely.
but yeah, I know one of my challenges is when with preparing witnesses is to get them to deal with somebody that's not so nice, maybe not so professional, very aggressive with the witness, right? But they could also be the same way with you in their communication styles, whether it be email or in court. How do you deal with these categories of this category of difficult attorneys?
Well, so I've got a pretty good analogy for this, I think. So I've got my youngest is 9 years old, and he's his first year of kid pitch baseball. So I told him, when you're up to bat, you've got one thing to worry about. You got to figure out if this pitch is over the plate. No, I'm going to swing at it or not. You got one thing on your mind. Well, let's say you put that context in the bottom of the last inning, and you're down to two strikes, and all of a sudden these emotions come up with inside you. You're
Yep.
you're anxious, you're fearful, you're focused on this extra thing that is not the job at hand. I think these attorneys that kind of be are bombastic and try to bully their way through a case, with a lot of defense lawyers, if we're being honest, it's a distraction from the real job, which is applying the facts to the evidence, applying facts and the evidence to the law that you have in the case, and advising your client of whether this is a case that we need to push on, or we have some exposure here. You really got to minimize that problem and maximize the job that you've been hired to do. So a couple ways to do that. I've had one lawyer in the last, this is about 5 years ago, he would email, and I really am convinced he scheduled these emails to go out on a schedule. It would come at like first thing in the morning or 6 o'clock as soon as you got home to the house, and it would be bombastic, and it would be here's part 17 of the email that I sent you last night, and it would just be off on these rabbit trails about personal issues with your client, or even you sometime. And what I finally figured out is I was better off literally having a rule in my Outlook inbox to take those emails as soon as they came in. They go in the case folder, and I just had somebody on my team look at them and say, all right, here's the issue. You need to be addressed. Or she sent a bunch of just garbage the last week trying to, jerk your chain. I'm gonna shield you from it. Now we can't turn off email, ignore it. That's called
Sure.
malpractice.
Yeah.
Um,
We don't want that.
but you've really got to do a good job and be creative in separating the task at hand,
Yeah.
defending your client and giving them good advice versus someone who's trying to, get under your skin and just uh make things difficult for the sake of making them difficult. And the appendix to that is those lawyers that have that tactic, whether it's purposeful or not, they really aren't doing anything to advance their client's cause in the case. The one example I'm thinking of from 5 or 6 years ago, we got to mediation, and I think this lawyer, she had rubbed her clients. She had been this way to everybody in the case, even to her own clients' points where they were ready to get rid of her, and the case settled for way less than I thought it would have. So, to call it a tactic is really not even fair because it really doesn't help their case or hurt ours necessarily. It's just an unnecessary distraction that you've got to sort of bifurcate yourself from.
Yeah, let's talk about how this plays out in deposition. So, we have a very sophisticated training program, as you know, and this is one
Yeah.
of the things that we prepare witnesses for. I posted on LinkedIn this week a story from one of the attorneys I was working with up in North Carolina, where he said he was at deposition and the plaintiff attorney was being a real jerk. And during the first break, and our witness was kind of playing into that and becoming a jerk himself. And so he pulled the witness out of the deposition during the first break and said, there's already one jerk in the room. Let's not make it two, right?
I love that.
Meaning it's so easy for the witness to become defensive and aggressive because you want to defend yourself. And you kind of, I think it's all bait. How is
Yeah.
it for the like, how do you yourself not take that bait? It's almost like trash talk. Well, listen, you were an athlete. You got a kid that's an athlete. I was an athlete. We're both super competitive. And I remember when I was growing up in the 80s and early 90s, particularly, I played sports that happened on the field with me. And then this is back when like the NBA, like this is when like men were men and it was actually very competitive. And it was the like one of the number one sports in the country, and like Michael Jordan and all these, Patrick Ewing. The amount of trash talk, like Larry Bird, biggest trash talker apparently in the history of the NBA. And I've seen interviews on these ESPN documentaries of like he would get in your head
Yeah.
and then you would like lose your cool, and then you're the one getting the technical foul, not Larry Bird.
It's always the second guy that
It's
gets
always
the
the
technical,
second
right?
guy, and you see this in college football, right? And like one of these Gators, I remember watching that one of the Gators games this year, and uh, our guys getting up off of the ground, and I think there was the Ole Miss game, which they won that game. That was a big win, and the Ole Miss guy, you could see him, talking in the Gator player's ear, and then what does the Gator player do? He shoves him, and then the flag comes out, and who gets the penalty?
Yep.
The player for the Gators, right? How do you emotionally keep it together when your adversary's really, really pushing it? Because I gotta tell you, I have videotaped depositions that I've watched where the defense attorney loses their mind as well, and that's not going to help out. How do you deal with that? Because I imagine your blood has to just boil sometime, and you have to
Yeah.
like really reel it in.
Yep. Yeah. You know, in terms of a deposition, I think that it's a much more difficult thing for a witness to keep themselves composed than it is a lawyer. But they've got to, the witness has to remember all that's coming out of this usually is just a transcript, unless you're not going to testify live at trial. So, but in terms of a lawyer doing that, I mean, a lot of it just comes with experience and realizing, what the end game is. But it's probably like any other stressful event in your life. You've got to get outside the context, find a way to vent about it, talk about it move on, process it. I'll come back and talk to folks on my team, and we'll go to lunch and say, man, you won't believe what happened in this deposition today.
Yeah,
In fact, people love hearing those kind of
yeah,
stories.
of course.
Nobody wants to come back from a deposition to go to lunch and say, how was the depo? We asked, 2 hours worth of questions, and everybody was nice and polite. They want to hear, you won't believe what this guy did. He started pounding his fist on the table, and he stormed out of the room, and he insisted we
Yeah.
print all these documents. And so, you know, venting, talking to people, find some kind of catharsis is helpful. So you can then go back into the war, into the battle, and keep a cool head.
Have you ever had, I've seen this before too. This is a really interesting topic, where a witness is being deposed, you're defending the deposition, plaintiff attorney's being a real jerk, right? And you're keeping your cool, and then you get to the break, and your witness is mad at you for not being a jerk back, going, hey, you're my attorney. How come you're not yelling? Like, he's pounding the table, he's calling me names, he's yelling at me, and you're sitting here being all cool and quiet. Like, what are you doing? Do you ever have to like explain to your client, like, hey, there's a method to my madness?
Yeah, they got to remember, except for some instances, if it's a video deposition, even there's only one camera and it's on you. So whatever he says, he will not be judged on. You will be judged on what you say
Yeah.
and do. So you got to remember that, and remember people, both the plaintiff's lawyer in terms of the value of his case, and the potential jury is going to evaluate your words, but also your demeanor and your how you're affected by it. Are you overly defensive and appearing like you have some guilt, for lack of a better word?
Yeah.
Or you calm, cool, and collected and in control of yourself. And if you're the latter, you're winning that battle. Um,
Now, is it ever this is a kind of little bit out of left field. Is it ever and I guess there's a difference between being a jerk and being tough, right? Is it ever appropriate, and maybe you've seen this, maybe you've done this, I don't know, that's why I'm asking, where say maybe you're deposing a plaintiff that is clearly not being forthright with you, or maybe it's an adverse co-defendant, or maybe it's like a plaintiff expert. Is it ever I guess warranted to kind of be a jerk yourself if you have a witness that's very adverse to you and maybe not being forthright, or you think they're being too difficult? Like, how far can you push it? But I would say probably when you're deposing a plaintiff expert, things can get pretty contentious, right? How far do you push?
yeah, I think that's a really good question, because it highlights the distinction between
Yeah,
being unnecessarily bombastic and a jerk and putting yourself at center stage
yeah,
versus controlling the witness, controlling their testimony, putting parameters around it. And sometimes that does mean you've got to cut people off.
yeah,
If you ask a question, they're going out of left field. If you've got a document that you just need them to agree, this is what I said. You don't have to be a jerk. You don't have to be louder than them. You don't have to pound your fist on the table, but you've got to control the witness to answer the question that you're asking. So I think there's a very fine line there.
yeah. And again, I think, and particularly, especially with, and again, I've seen this. I've seen defense attorneys be jerks to witnesses too. So I think everybody's susceptible to it, and it's something that. And again, I want to finish with this as you're training your younger attorneys to give them this type of guidance, because listen, whether it be witnesses or it be attorneys or you as a father or a husband or a friend, emotions get the best of us. And we all
Yep.
know when we get emotional, we say dumb things, we say hurtful things, we make mistakes. It's generally not a it's not a good thing in any of this, and having control over that's important. Let's shift categories. So the next category here is the plaintiff attorney that's either too busy or too lazy, right? The ones that I'm sure this has to drive you insane. They're not returning calls. They're not returning emails. You finally get them on the phone and they're like, what case are you talking about?
Yep.
Now, I guess there are some attorneys, I guess I I'm gonna fall on the sword here. I get my own colleagues calling me like, "What's going on with this case?" I'm like, what are you talking about?" Like I haven't like, okay, hold on, give me the case name, show me, and then I kind of figure it out. I'm like, oh, okay, I get it. Not because I'm ignorant, because I'm so busy,
Yeah.
I get scatterbrained, right? But then I can imagine there's also some lazy folks out there too. How do you deal with somebody that you're trying to communicate well with, you're trying to be productive with, and be a good guy, and they're not responsive for whatever reason.
Yeah, I think that's a time when you got to sort of align goals with the other side. If you can get their ear, and typically a phone call goes like this: Hey, Bill, I'm calling you out of the blue. I'm probably catching you flat-footed on this, but my client's got some attention on this case, and I wanted to see if we could talk about where this is headed. If this is not a good time, could I give you a few minutes today to kind of get your head around it, and let's talk tomorrow? You know, anytime, regardless of how busy they are, if the opposing side realizes they can get some money out of a case, or they can, and usually both, close a case with less work, you
Yeah,
kind of got their attention. All right. So you're
yeah,
helping
yeah,
clear their plate. We're moving the ball forward. We're kind of working together on this. I think you become sort of a mutual problem solver.
yeah,
And really, you're in reality, you're helping your client because your client has the same goals too. They want to get to the end game, whatever it is, sooner rather than later. So
yeah,
just align goals with the other side, give them a chance to get organized. And you know, if and that still doesn't work, if you're still not getting discovery responses, and you know, you can always uh motion up the case a little bit and get them before a judge who's going to give them some deadlines. But that's really not the preferable approach, because then you're spending, clients your time, clients' money on things that really shouldn't have to happen. So
yeah.
I tend to try to just align goals with those side and help them realize that we're both trying to push this thing in the same direction.
Yep. And you can only do so much, right? So another category, and it sucks that we have to bring this up, but this happens. I guess we could call this category the unethical category. I'm not an attorney, so you know the ethics far better than me. I listen to a lot of podcasts. I listen to a lot of plaintiff attorney podcasts, and they have some really good podcasts. They're well done. They break down cases and stuff. But there was a podcast the other day I was listening to where essentially like the topic was like how to put lipstick on a pig, like how to get big damages on a case you have no business getting big damages on, and it kind of made you wonder. It's like, is that is should that really be happening, right? And it was always like little tricks like, so it's like when you don't have a good case, but you're going to do all these things to try to make it a good case even though it's not a good case. Do you want to talk about this category, because this is kind of tricky, right?
Yeah, I've got it's funny you said that. There's a firm I'm aware of whose mantra to their team is, we don't get good cases, so we have to make them good cases. And
Yeah,
that
that's
sounds good,
yeah. What?
but it sounds like I'm going to do something that, and maybe I'm going to get an affidavit from a friend that doesn't say, says I saw beer cans in the car, or whippets or something like that, and it really maybe didn't
Yeah,
happen. So what do you do about how do you handle that one? Well, typically picking up the phone and calling them is not going to produce a whole lot. So,
yeah, yeah,
you really just got to vet and call out their their positions, their factual assertions. If you get an affidavit, pick up the phone and call a witness. Hey, I want to meet you, and did you sign this? Did somebody else draft this? What's really your story? Good investigation on the facts tends to hedge against people who are going to make up facts.
yeah, yeah. um Final category. I'm adding a category to our list because this has been
Okay,
coming up. This has been
love
coming
it.
up quite a bit, and I'd love to get your thoughts on it. I'm going to call this the unrealistic plaintiff attorney, the one that calls you and you have a slip and fall, and they're like, demands $20 million, and you're like, I'm sorry, did you say
Yeah.
20 million? And they're like, yeah. I guess another way to put this category, which I'm sure, listen, this happens all the time, is the plaintiff attorney that maybe is trying to make a name for themselves. They want to get a headline, they want to get press clippings, they want to be able to put the big W on their website from a business development and marketing point of view.
Right.
Therefore, the like for example the demands that they're giving you, particularly very early in the case, when you know this case is maybe $1 million and they're asking for 15 or 20, I think that's happening a lot. Number one. Number two, whether you like it or not, I've read all the reptile edge materials. They actually, that's part of this, is to create a lot of anxiety between the defendant, the attorney, the claims person, and that if there's an expert, they want everybody to be nervous and be in fight or flight. And what's a good way to do that? Well, to throw out a pretty ridiculous number early, which is a real threat, right, to everybody on the defense. I see this happening more and more. How do you deal with the unrealistic plaintiff attorney that's coming out with numbers that are just out of this world?
Well, the first question I kind of ask myself, and I don't always get an answer to it, but are they creating these expectations for their client? Yes or no? If they are, then you've got a little more of a problem to deal with, because they've now all of a sudden lost client control, whether it's because of something they've told them or a billboard they've seen or the business development marketing of a prior big verdict. Side note, we've got a couple of firms I've run across who will take a minimum limits auto case at 25,000. They've offered defendants offered that money, and they just want to go get the verdict. There's no
Yeah.
uninsured motorist coverage. They're trying to, leverage sort of maybe a position between the tortfeasor and their carrier. So that's a problem if they've created unrealistic client expectations as well. But if not, if you think they're just trying to put you into fight or flight, which is a real thing, I think, then you've got to just take the long game on those
Yeah.
cases. I think a
Yeah.
little bit. I think, the theory on there is if I start high, I have more room to move.
Hmm.
And I'm gonna try to get them to move when I don't move. I'm gonna stay high. So, clients want their cases resolved as quickly as possible. But sometimes you got to realize this one's going to take a little longer, and we've got to do some work and make them work. I think that's one thing busy defense attorneys can do a better job of in cases like this,
Yeah.
is making the other side do some work on the case. It takes them 15 minutes to whip out a, ridiculous demand. But if they've got to answer interrogatories, sift through documents, meet with their client multiple times, then they might start getting a little more realistic if they've got to invest some time in a case.
Yeah. Well, this has really been great stuff. And again, I want to make this clear. I think probably there's many defense attorneys that could be accused of everything that we've just been talked about. I think it does.
Yep.
There's good and bad on both sides of this. Maybe I will have to have a plaintiff attorney on, which will probably get me in a bunch of trouble, and everybody will get mad at me to see how they would classify defense attorneys. That'd be
I
kind
would
of
love that.
interesting. Well, let's see. I'm sure, because trust me, they listen to the podcast. They
Yeah.
email me, and they're actually really nice to me. They're like, "You have a great podcast," and I
Yeah.
listen to it. I'm like, "Okay, well, thank you very much." But we're
Well,
not
let me
like,
let me let
yeah,
me jump in and just
yeah,
add, I think I prefaced the whole conversation with this, that by and large, we are less civil than we've ever been, but this is not every day. These
yeah,
are categories of people I deal with, on a yearly basis.
yeah,
But, you could pick a random plaintiff's attorney that listens to your podcast, and I would, just by percentages, bet they're easy to align goals with
yeah.
and work with. It's just a reality we've got to deal with it. Not everybody's like that.
Yeah, and the fact that I think this is an important point. I think what you're saying is the majority of your interactions with plaintiff attorneys is positive and productive, and that's good. But this stuff is going to happen, and your young attorneys are going to have to deal with. So let's finish up here on the final topic. Kind of two questions, a two-part question. Number one, what is your personal and Christian and Small's kind of philosophy of training and mentorship of young attorneys? And we have many, many young attorneys that listen to this podcast. what are maybe a couple of tips or just some guidance to give them as they're developing with their careers? Because one of the negatives we've seen, Jim, is a lot of younger attorneys bouncing around firms because things aren't coming
Yeah.
quick enough or that it's like so what's your philosophy, Christian and Small, and then maybe some kind of general tips from the younger attorney trying to make a name for themselves and to grow within a firm.
Well, my approach on my team, we work with associates and teams. One thing that's important is those teams are not exclusive. So if I have everyone who works on my team has at least one other partner they work for, um, because it's important for them to realize that not every lawyer works the same way.
Yeah.
Neil Moore does things differently than I do, and Neil is a fantastic lawyer. He and I share an associate, and I think she really gets the best of both worlds by seeing Neil's approach to things, Neil's thought process, and mine as well. And there's some similarities and there's some differences.
Well,
So,
he went to Georgia. That's the first that's the first problem with that, maybe, right? He's gonna
first of
listen to this
many, but
podcast. He's gonna be mad at both of us. We got to pick on Neil a little bit,
yeah, absolutely. He's earned it for sure.
right?
Second of all, my team has a meeting once a week, and
Good.
it's sometimes it's a 5 minute meeting on Mondays at 8:30. Sometimes it's 15 minutes, and just having that touch point to
Yeah.
know that if I've got an issue, I've got a time and place to bring it to talk about. I think is helpful. And then as we've grown, I've kind of developed. I've had a very open door philosophy, but I've kind of had to hedge a little bit and say, "Hey, if you want to talk about something, let's pick a time because that way I
Yeah.
can be more focused.
Yeah.
Even if it's like, are you free in 2 hours? I'll say, nope, but how about 3 hours at 3:30? Have a time and place where I can, turn my desk around, talk to them, not worry about what's happening for 15 minutes and just, making myself available. And then asking a lot of rhetorical questions. I love um, when someone comes in with a question, my first response is, well, what was your first thought? What do you think you should do about it? And let's talk about that. Or what do you think this case is worth? Don't
Yeah.
let me tell you what it's worth. What do you, and just kind of asking some rhetorical questions and getting them uh, thinking, getting their juices flowing. There's no shortcut to spending time with people and developing a relationship to where you have that comfortable dialogue. And I feel like honestly we do a really good job of that here,
Yeah.
which is why we've been able to retain a great team, great associates. I think that by and large the people that have left have gone to an in-house job. We've had
Yeah.
one move to Washington for she got married and things like that. But I really feel like we're developing a good team. It's because we take the time and build a relationship with them to invest in conversations about how the best way to practice law is, how to talk about some of these topics and these people we've learned are issues and cases, and just making yourself available to them.
Sounds excellent. Well, Jim, thank you so much for being on the show. Stick around so you and I can chat after. To our audience, thank you again for participating in this edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences. I am Dr. Bill Kanasky. We'll see you next time.